my true crime lovelies. How are you? Oh my goodness, I've got a good video for you tonight, so I hope you're going to catch that premiere. But in the meantime, I was Docket watching, and I got a couple of little quick updates for you. So, number one, we talked about the new attorney, Mr. Owens, and how he was, he's Sarah owes me. Well, I've talked about it. You guys haven't seen that yet. But anyway, so he has finally logged something that says that he is pro bono because he filed something with the court asking for declaration of indigency and payment of of undue, not of undue, of due process. Let me just show you guys that one. Here we go. You guys can see that. Make it a little bit bigger. This was filed on the 3rd, that evening after court. And so it's a motion for a declaration of indigency. Oh my God, indigency and payment of due process costs comes now defendant Sarah Boone by and through undersigned counsel. Although I think this is a typo because her name is Boone and not Compton. I think they're rushing. But defendant Compton has been charged by information with second-degree murder. The defendant has previously been found indigent for costs by the court. Undersigned counsel has agreed to accept this case pro bono and has not received any payments toward legal fees. The defendant has been notified of the additional costs that will be needed for experts and investigators to fully investigate this case and prepare for trial in this matter. However, she is unable to pay for these costs. Undersigned counsel needs to fully investigate this case. Undersigned counsel feels that defendant's rights may be severely prejudiced if she is not able to investigate the case. This motion is made in good faith. Wherefore, defendant Sarah Boone. Wait a minute. Defendant. Oh, yeah, I skipped right over it. Sorry, somebody was waving to me. Undersigned counsel has agreed to accept this case pro bono and has not received any payments towards legal fees. So there you have it. There you have it. But what I really wanted to tell you guys while I was let's see, while I was docket hopping or watching or whatever you want to say, there's someone else who's signed on as co-counsel. So before she didn't have any, now she has two. It's like manna from heaven for Miss Boone, which makes me even more excited because for sure she's going to get a fair trial. So this was also filed on Tuesday, but with, there's so much other stuff going on. I missed it. I didn't see it until today. So let's get over there. Here we go. Notice of appearance as co-counsel. Notice is hereby given that Kevin T. Beck hereby enters this appearance as co-counsel to James Owens Esquire on behalf of the defendant, Sarah Boone, in the above styled case, which is, as we know, there we go, above styled case, state of Florida versus Sarah Boone. Certificate of service, electronically file the proceeding with the clerk of courts by using the e-portal system, which I understand will send a notice of electronic filing to the office of the state attorney, and he signs it, co-counsel to Sarah Boone. So now she's got two lawyers. So of course I had to go be nosy. Who is this Kevin Timothy Beck? I matched it up to his bar number, which is 802-719. You can see that there. Let me make this side bigger because we don't really need to look at that other side. 802-719 on this document, 802-719. His law office says that it's in New Mexico, which obviously he has a Florida bar number. His county is non-Florida. He has some disciplinary action. And so I clicked on this, the reference number. He was admonished on 5/7/2021. That's my birthday. And that admonishment, report of minor misconduct. So in the Supreme Court of Florida, before a grievance committee, the Florida bar is the complainant versus Kevin Timothy Beck, who is the respondent. Basically, he misallocated some funds. The committee accepts respondent's tendered admission of minor misconduct and recommends that respondent receive an admonishment. The admonishment will be administered by service of this report. So they're just making it public. That's his only um, punishment for that, is admonishing him publicly. Summary of misconduct and rule violations found. This matter was initiated after the bar received a notice of insufficient funds bounce check on respondent's trust account dated October 28th, 2019. A check for $22,287 was presented for payment when the trust account had an available balance of $1,668. The check was returned unpaid by the bank. Let me find out. You over here bouncing checks. Like how you can bounce a quarter off a bunk when you're in the military. Boing. That is how that check bounced. Okay, so then, um, had the check been paid by the bank, the result would have been an overdraft of $20,618. A second NSF dated, so basically they're saying you were up short $20,000, right? And then a second one, dated November 27th, was received by the bar for the same amount. So he sent a check, it bounced, they sent it back. Most people will run it through twice, right? Or most banks, because it's not like you're standing there doing it, but most banks will run them through twice just to see if, for whatever reason, it hit before a balance was recognized, and so he got a second one. Respondent explained in response that in mid-October 2019, he was advised by his business partners that he needed to provide funds from his trust account to be put in the court registry for a business venture he was involved in. Because respondent was out of town at the time and could not access his trust account, respondent asked his daughter to transfer $22,287 from respondent's personal investment account into his trust account, and then asked her to write a check from his trust account to be deposited into the court registry. After being notified of the first NSF, respondent determined that his daughter inadvertently had transferred his personal funds into his operating account instead of his trust. Respondent admitted in his response that he utilized his trust account for this business purpose, but asserted there were no client funds involved. After reviewing this response, a request for respondents' trust account records were made for the period October 1 through December 31st. So they called him out on it, the bar, right? Because he bounced two checks. And so then he provided a response explaining his daughter put it in the wrong account. He was out of town. I'm guessing you can't make digital transfers in this kind of trust. You have to physically go into the bank, it sounds like, because wherever I am, I can transfer money usually. So, as long as I have an internet connection. So he gave the response, they reviewed the response, they asked for his account records, right? They trust but verify. And so after that, he submitted those for the period of October 1, 2019 through December 31, 2019, right? So for the time in question, they didn't go over and uh, above. So they wanted to just, trust but verify. Respondents' trust account records were not in substantial compliance with the rules. Ruh-roh. The bar asked respondent to explain who the balance of $1,668 in his trust belonged to. Respondent explained the funds belonged to three prior clients he had been unable to locate after he completed their representations in or around 2012, and he had treated the funds as abandoned. So it really belongs to clients. It sounds like this might be the client trust account where you have to hold it in trust and not commingle it. Although it's a little confusing because he says he also had some money in here for a co-venture. So I don't know. Anyway, substantially not compliant is what they said. Respondent admitted that as of April 2020, he did not have sufficient funds in his trust account to reimburse one of the clients and explained he inadvertently used a portion of the client's funds during the federal shutdown in 2019. So you should not be able to inadvertently use your client's trust account. So it's something's up, but again, he's getting this admonishment. In September 2020, respondent replenished his trust account with sufficient funds to refund each of the three outstanding clients and hired a PI to find the clients and return their funds. The funds were received by each of the clients as of October 2020. Respondent was holding only the funds allowable under the rules to cover bank fees and no other client funds in his trust account. The bar took respondent's sworn testimony in September 2020, which if they took it in September, how do they know that the funds were received in October, a month later? Either way, and respondent admitted his error and further admitted that his record keeping practices for his trust account were inadequate. Based on the foregoing, respondent violated um, comment on mitigating, aggravating, or evidentiary matters. The committee believes that the following comment on mitigating, aggravating, and evidentiary matters will be helpful in considering acceptance of the report. Respondent fully cooperated with the bar in its investigation and admitted his failures in his trust accounting practices. Respondent took additional steps to ensure that his errors were corrected. Committee found that respondent's misconduct was done negligently and not with intent, not intentional to defraud or otherwise deceive his client. So he wasn't up to no good. He wasn't doing an Alec Murdoch, right? And further found that he was genuinely remorseful for his actions and probably embarrassed too, you know? So we all have that like one dirty drawer in our finances, like our junk drawer from a financial perspective, and we're hoping nobody digs into it. And it sounds like they got up in his business. So I'm sure he was remorseful and probably a little embarrassed. Okay, so respondent practices primarily in federal criminal defense. Ooh, like RICO stuff. And the majority of his work is done through appointments, so he does not often hold client funds. Okay. Additionally, respondent has recently been offered a position with a federal agency where he would no longer be required to maintain a trust account, and he ain't gonna be holding one with Sarah either because she's broke. Respondent is an experienced practitioner with no prior disciplinary history and possesses a good character and reputation. Admonishment. Kevin Timothy Beck, your actions have discredited the legal profession of the state of Florida. Such conduct cannot be tolerated by your fellow lawyers and should not be tolerated by you. Pride in your profession demands that you not violate the rules of professional conduct. Again, if you do, your present misconduct will be considered in future disciplinary proceedings. Then he's got to pay for this little spank on the butt or on the hand. The administrative cost, 1,250, and then the court reporter fees and transcripts for documenting all of this, 429. So he owes them $1,600. So any person now or hereafter licensed to practice law in Florida shall be deemed a delinquent member if the member fails to pay the costs assessed in diversion or disciplinary cases within 30 days after the disciplinary decision or diversion recommendation becomes final, unless such time is extended by the Board of Governors for good cause shown. Delinquent members shall not engage in the practice of law in Florida, nor be entitled to any privileges and benefits accorded to members of the Florida bar in good standing. A quorum consists of not less than three members of the committee being present, two of whom are lawyers. The committee, by affirmative vote of a majority, voted in favor of the recommendation as stated in item 1 above, or item I, it might be. Um, and then it has the people in favor of the report, 8, against 0. So everybody was with it, and it was filed on, what did I say, the 7th. So there. I would say, though, like, if we view that one as a bad guy, helping out Sarah pro bono is definitely a good guy. So we're gonna forgive his little accounting mistake and we're gonna move on. All right. One last thing I wanted to show you guys because y'all may have missed it. Some of Sarah's info on mainly her laptop shenanigans, but inmate behavior notes. So on the 26th, which I believe was the third meeting in person that James Owens had with Sarah, on 8/26, and this is Nadira who's writing this, I heard loud yelling from the hallways. Upon further investigating, I realized it was coming from the briefing room. The briefing room was occupied by inmate Boone and James Owens. Due to the loud disturbance, I entered the room and informed inmate Boone and Owens that they are causing a disturbance. Owens informed me that everything was good, that they had a little disagreement. I don't want a disagreement with somebody who gets mad and puts people in suitcases. After inmate Boone interview meeting, I spoke to her about retrieving a grievance form. Inmate Boone informed me that she did not need a grievance form. So I'm not sure if that's related to this. It doesn't sound like it, like maybe before she'd asked for a grievance. Maybe they're in the habit of just giving her a grievance form because she often is grieving about something. There's not a lot of context there. Due to standard operation procedures, ACA accreditation, our monthly shakedown was conducted. Inmate Boone was offered the opportunity to utilize the laptop at approximately 21:26 hours, to which she refused. An OP60 was generated, probably just to say there was a refusal. So no cheese slices. I did get all of her behavior reports since she's been in there. I'm gonna do a video on that one, but oh my goodness, I'm with you guys on the cheese slices now. I understand. And then on August 30th at approximately 11:58 hours, inmate Boone completed her interview and viewing of physical evidence. I conducted a strip search at the conclusion of the interview and escorted inmate Boone back to her unit. Strip search? That must be procedure because I'm like, I don't think she would have put anything from the evidence upon her person, but I could be wrong. And then for those of you guys who are along with myself, were hoping that she no longer had access to the laptop after her attorney filed notice of appearance on the 28th. She still had it the 30th, 31st, the 1st of September, the 2nd of September. So maybe they'll still take it from her. Maybe at this point, I don't care. I just don't want her giving the guards a hard time about it because, girl, I think, though, she's on cloud 9 as we saw her in the courtroom. Even after her motion for continuance was denied, she still seemed lighter than we had seen her previously in court. So I think hopefully that when things are going well for her, she has a reason to not agitate people. I'm trying to give her grace. Like maybe she just doesn't know how to regulate her emotions. And so when she's in a bad way, she makes everybody else in a bad way. And now maybe I mean, she's still looking at life. So I don't know how much of a good way she's going to be in. But this should be a burden. Be grateful, show your higher power that you are grateful and understanding. And, good things will continue to come, not better than what you deserve, but I pray everybody gets exactly what they deserve. So, all right, I'll talk to you later. That was just a quick little tidbit I wanted to let you guys know. New counsel on board. She's got two. Oh my gosh, she's got two. So I feel like this one will stay. James will stay because now his buddy is signed on as pro se as well. And so he can't just leave him, right? So I don't know if this guy has met. I was looking in the notes if he's even met Sarah. Maybe he's doing paperwork, but he put co-counsel so he can appear in court. So I'm sure James has let her know on the backside so they don't just show up one day and he's there and she'll be like, I don't know what's going on. I don't know why he's here. I don't know why I'm here. You know the drill. Talk to you later. Toodles.